Very well. Without further ado, I will start my talk. So just give me a moment and I shall set up the PowerPoint running. Right, I hope everybody can now see the slides, which I'll then just go through. So why is duty of care so important? This is first year law student stuff, really. But it's important to remind ourselves of what the elements of a claim in negligence are, summarised in Clarkland's The Torts, relevant type of harm being the first element. Secondly, what we're focusing on here, the existence in law of a duty of care situation, one in which the law attaches liability to careness, and the one that the law recognises as potentially actionable in the tort. Thirdly, breach of that duty. Fourthly, causal connection between the careless conduct and the damage. And finally, the issue of remoteness. We're focusing, as I say, on number two. It's easy, isn't it, when you first get a case to focus on whether there's fault. But this particular element, of course, it needs to be determined without reference to fault. There's been a particularly vivid illustration of that recently. So it requires, regardless of who you're representing, it requires a clear focus. And perhaps your first question, is this a situation in which the police owed a relevant duty of care? The reason why it's so important is, first of all, it acts as a filter, so the police are potentially liable to all claimants for all types of harm that they suffer. Secondly, it's a control mechanism which keeps negligence liability within reasonable bounds. And thirdly, it offers you the option of seeking strikeout in an appropriate case as showing no cause of action. And that, of course, will avoid, on both sides, there being expensive and ultimately futile investigation into the facts at a trial. So it's relevant to have regard to the historical position. I'm going to start with briefly reminding ourselves of the case of Hill. That was about the Yorkshire Ripper, for those of us old enough to remember those tragedies. The mother of the final victim brought a claim against West Yorkshire Police for failing to apprehend Peter Sutcliffe before her daughter's death. The House of Lords confirmed that no duty of care was owed for two reasons. Firstly, that if there was no duty owed to the general public to capture a known criminal, there was no duty owed in relation to one like Sutcliffe, whose identity was not known. And secondly, and this is what led to some difficulty, it was contrary to public policy for a duty to be owed because it would lead to a defensive mindset and distraction from tackling crime. And then subsequently, Hill was applied in a number of contexts, and here are some examples. Firstly, El Ghazouli Daf, no duty owed to detain suspects in relation to ongoing investigations. Then Brooks, Mr. Brooks was the friend of Stephen Lawrence, who witnessed his tragic racist murder, and it was held that no duty of care was owed to him to identify the witness, to him as an identified witness of the fatal attack. He recovered damages, however, on other grounds. In the Smith case against Chief Constable Sussex, the deceased murder victim was a witness against the perpetrator, and again, no duty of care owed to that complainant to protect him from the perpetrator. The public policy ground for the decision in Hill was largely discarded in those decisions. For example, in Brooks, it was said that we're more sceptical about things these days. But the reasoning related to the breadth of duty and lack of any particular feature giving rise to liability remained valid. It was widely thought for many years that the police had a so-called immunity, therefore, from claims of negligence. That was a mistaken position to adopt, as we shall see. So we now need to look at two cases which illustrate the modern approach to negligence claims against the police. First of all, Michael. This was a case where the victim made a 999 call, which was received by the neighbouring police authority and relayed to her home police authority. The call was graded as requiring a 60-minute response. During that period, the victim made a further call and was heard to scream, and sadly she was murdered by her former partner. The estate and her family made claims under Article 2 of the Convention and in negligence. The Supreme Court held by a 5-2 majority that no duty of care was owed. Lord Toulson gave the judgment for the majority. He emphasised the distinction between cases where the defendant caused injury to the claimant, and secondly, cases where the defendant failed to protect the claimant from injury caused by a third party. He said, importantly, the same rules apply in negligence to the police as to private individuals and bodies. There is therefore no question of the police having any sort of special immunity. This quote from Michael is of wide application in police cases. It does not follow from the setting up of a protective system from police resources that if it fails to achieve its purpose through investigate organisational defects or fault on the part of an individual, the public at large should bear the additional burden of compensating a victim for harm caused by the actions of a third party for whose behaviour the state is not responsible. To impose such a burden would be contrary to the ordinary principles of the criminal law. They then went on to consider the case on the facts. It wasn't possible to confine duty of care by relation to particular types of crime or victims, such as domestic violence victims. There was no way to know if imposing negligence liability would improve the police response to domestic violence, but it certainly would have substantial financial implications by giving rise to more claims. The fact that the claimant had an arguable Article 2 claim was not a reason to expand negligence liability, and the police have no liability generally in cases of pure omission by the police to perform their duties for the prevention of violence. Robinson was a case brought by an elderly lady who was knocked over in the street in the course of struggle between police officers and a suspected drug dealer. She brought a claim against the police in negligence for her injuries. At trial, it was held that the police were negligent in trying to arrest the dealer when members of the public were in the vicinity, but the police could not be sued in negligence as a matter of law. Eventually, it got to the Supreme Court. The court first of all said that the existence of a duty of care is to be determined by looking at previous cases and what was described as incremental development, not by the application of the three-part Caparo test that we all learned at university, i.e. foreseeability, proximity, and that it's fair, just and reasonable for a duty to be owed. Public policy would only be relevant if the existing cases did not provide an answer. And it generally makes no difference if whether the defendant's a public authority or private individual. That, of course, was something that had been said in Michael previously. Paragraph 33, this important passage, making it clear that the general principle that public authority can be liable on the same basis as a private person or body is subject to the possibility that the common law or statute may provide otherwise, for example, by authorising the public in question. Conduct in question. And that, of course, is particularly relevant to the police, who do have very wide statutory powers and duties in determining whether they can be liable in negligence. And it's confirmed that Hill does not establish general immunity for the police in respect of anything done in the course of investigating or preventing crime. And 34, another important passage, they cite this article by the academics Tafaris and Steele, which has been hugely influential in this area, where they said this: in the tort of negligence, a person A is not under a duty to take care to prevent harm occurring to person B through a source of danger not created by A, unless 1, A has assumed a responsibility to protect B from that danger, 2, A has done something which prevents another from protecting B from that danger, 3, A has a special level of control over that source of danger, or 4, A's status creates an obligation to protect B from that danger. The court in Robinson distinguished Hill and Michael, where the police played no active part in the critical events. The claimant's claim is based on the acts of the officers, not an omission to protect her. It was reasonably foreseeable that the subject might try to resist arrest and that a bystander might be injured, and therefore the trial judge had been entitled to find the police were negligent. The actions of the suspect, it said, did not break the chain of causation. So Mrs. Robinson was owed a duty of care by the police not to injure her while the police tried to arrest the suspect. Let's now look at some recent applications of this principle. I'm going to look at a number of cases that have been decided over the last year or so. First of all, Tindall, another decision of the Supreme Court. This was a case arising out of a road traffic accident. On a cold winter's day, a driver, Mr. K, lost control on black ice while driving along an A road and crashed. He got out of his vehicle and public-spiritedly began to flag down approaching vehicles to warn them. The police attended and put up a police slow sign and removed the accident debris, but took no action in relation to the ice. Mr. K, an ambulance arrived and Mr. K was taken to hospital. The police then left the scene, having cleared up, taking the sign away with them. And inevitably, there was a further accident. The claimant's husband skidded on ice and sadly suffered a fatal accident. So the Supreme Court gave a statement of principles at paragraph 44, worth remembering as a source. I'll extract the relevant ones. The third one, it really deals with how you distinguish between an act and omission. They say this: the difficulty in drawing the distinction between making matters worse and failing to protect from harm is how to identify the baseline relevant to which one judges whether the defendant has made matters worse. The cases show that the relevant comparison is with what would have happened if the defendant had done nothing at all and never embarked on the activity which has given rise to the claim. The starting point is that the defendant generally owes no common law duty of care to undertake an activity which may result in benefit to another person. So it's only if carrying out the activity makes another person worse off if the activity had not been undertaken that liability can arise. They go on to say that you can also look at it by saying that you take a duty not to expose others to unreasonably foreseeable risks of physical harm created by your own conduct. And then point 5 refers to the exceptions. And we've already looked at so far as the Steele formulation, which was considered closely in that case. So importantly, they say at paragraph 45, in deciding whether it's an act or omission case, you must view the conduct of the defendant as a whole. Often, claimants seek to characterise elements of the history as that should, in fact, arise as positive acts rather than omissions. That slide should say when they frame their claim. So, for example, when you consider the case of when someone parks a car and fails to apply the handbrake, is that an act, a case of omission? The answer is no. They say any difficulty in explaining the common sense conclusion that the driver owes a duty of care disappears when the focus is directed at the whole activity of driving. And the question is asked whether the damage would have occurred if the defendant had not engaged in that activity. Plainly, the answer is no. So viewed, it can readily be seen that the case is one of making matters worse. So the police, so suppose a police car runs over a pedestrian on a Pelican crossing. That police driver can't escape liability by saying, well, my case was one of omission because I didn't apply my brakes in time. The activity is driving, and therefore the claimant's injury clearly results from an activity, an act of the officer rather than an omission to brake. Defendants' arguments on appeal to the Supreme Court were, first of all, the police made the situation worse. If the police hadn't arrived, Mr. K would have continued his efforts to warn other road users. And secondly, that some of the exceptions applied. In particular, it was said the police took control of the scene and then relinquished it without taking steps to protect other road users. The court considered the second Tavares and Seal exception, preventing another from protecting C, which they said is in fact the same as making matters worse. So it's not actually really an exception at all. They characterised it as the interference principle and quoted from another textbook: if A knows or ought to know that B is in need of help to avoid some harm, and A knows or ought to know that he has done something to put off or prevent someone else helping B, then A will owe B a duty to take reasonable steps to give B the help she needs. That is, they said, a correct statement of the law. However, in this case, there was no evidence that the police should have known that Mr. K was trying to warn other motorists. There was no evidence that the officers had discussed it with him. And there's no basis for refraining from striking out. The basis that the facts needed further exploration at a trial. Another confirmation that the court should not be reticent about striking out an appropriate case. Then they considered, so far as exception 1, the assumption of responsibility. There was none because there was no communication with the deceased by the police to be relied on. If, for example, the police had put something out misleading out on the radio and he'd heard it on the radio, who knows, that might have helped, but that couldn't avail him here. Control was then considered. On the facts that failed, the police didn't have control over the accident scene because the accident in which the deceased had died had occurred, in fact, some way down the road. There was a large extent of black ice that ran all the way down the road. And the fact that someone has a power of control, including making ineffective attempts to take control, is insufficient to give rise to liability without an actual exercise of control. And then they looked at the other exception, which is the status of the police, and said, well, that's not actually a separate exception at all. That's what the academics thought should exist as an exception. So that deals with the very important decision of Tindall. Now look at some others. Holbeach, a Northern Ireland case arising out of the 1987 Remembrance Day bombing in Enniskillen. The bomb had exploded in a building called the Reading Rooms, which was close to the Remembrance Day parade. The plaintiff, as they call Northern Ireland still, was a bystander who suffered severe injuries. And he alleged that the police operations in checking for bombs was negligent. The plaintiff's case, as clarified at the hearing, had 3 elements to it. The police were said to have assumed responsibility to take reasonable care for the safety of the plaintiff by undertaking a security operation, which included searches of inter alia premises and places. They thereby encouraged the plaintiff to rely on the security operation, and he did so. And C, that they failed in their responsibility, which they'd assumed, to take reasonable care by failing to search the reading rooms and discover the bomb. The defendant's argument was, well, we don't owe that duty to the claimant, we owe that duty to society as a whole. And if someone's injured, they can't sue us in negligence. The plaintiff's case was criticised by the Northern Ireland Court of Appeal for seeking to elide the distinction between an act and omission. And this is a useful passage from the police point of view. Overcomplication and sophisticated analysis are more likely to obfuscate than clarify in a case of this kind. The simplicity of the plaintiff's case is unmistakable. It centres around a single failure, namely the failure of the RUC to search the reading rooms. This, on any sensible analysis, cannot be converted to the positive act for which the argument contends, namely the inducing of a certain state of mind on the part of the plaintiff. Nor can it be acquainted with causing harm or, so far as distinct, creating material danger. It's an omission, plain and simple. So once again, you've got emphasis there on seeing the wood rather than the trees. Don't allow the way the claim is framed, in, for example, a letter of claim, to cloud the proper analysis of it. And there was no basis, they said, for inferring an assumption of responsibility, and so the striking out of the claim was upheld. Luke's, this was a claim brought against Chief Constable of Kent and the local mental health trust there. Series of events. The claimant was arrested for assault and detained on August the 11th, 2020. The police were informed by the claimant's family of their concerns for him. A nurse said that the claimant was fit for interview, and he was later released on bail. On August the 15th, he had contact with the community mental health team, and on the 19th, he was seriously injured in a suicide attempt. In relation to the police, the judge said, first of all, it's a paradigm situation of assumption of responsibility on the part of the police when the claimant is detained in custody. So when the police detain someone in custody, they owe a duty to take reasonable steps to safeguard that individual. One of the arguments for the claimant was that the police should have disagreed with the nurse's assessment, and it was held the police were not required to carry out an audit of the opinions reached by the clinicians about the fitness of the claimant in all the circumstances. So the claim against the police was struck out. Ward. This is a decision of Master Sullivan. The question before her was whether to give permission to proceed with the claim under Section 329 of the Criminal Justice Act 2003. It's a dog bite case. My rule with dog bite cases is that if the claimant's a villain, he's going to lose. If the claimant's innocent, he's generally going to win. So what happens in that case remains to be determined. But the master did give leave for the claim to proceed. The defendant's argument was, we don't owe a duty of care to the claimant here, because in the case of Bellino, where the claimant jumped out of a window to escape after he was arrested, the police were not held to owe any duty of care to him. The master says, well, I think it's arguable that Bellino did not prevent a duty arising not to cause harm or continue causing harm by the use of a police dog. So potentially quite an important question about whether when you start owing the duty of care to a detainee. Bell, an interesting case, this one, because it's one where liability in negligence was established. What happened here was that the claimant was in dispute with his former partner, Kay, who was a Brazilian national, over their son. The police had obtained the son's passport from the partner, but later returned it, and she abducted him and took him to Brazil, where the claimant was not able to see him. He brought a claim against the police under the Human Rights Act and in negligence. Mrs. Justice Hill found that a duty of care did exist and existed on three separate bases. First of all, she applied what was said in Robinson about reasoning by analogy from decided cases. In the case of Al-Kandari in 1988, the Court of Appeal had held that a firm of solicitors could owe a duty of care to a parent not to release their client's ex-partner's passport to them. The ex-partner then used it to harm the claimant. That was a decision which was closely analogous, said Mrs. Justice Hill, and therefore the police should owe a duty of care on that basis. She said that there's an assumption of responsibility because the police had assured the claimant the passport would be retained by them, and the claimant had relied on those assurances by not taking urgent legal action to prevent his son's removal. And finally, she said, although a bit more tentatively, the police created the danger of the boy being abducted by returning the passport to the partner. So therefore, that was a case where the police were liable in negligence as well as under the Human Rights Act. And then the case of Woodcock, cases of Woodcock and CJ, decided together by the Court of Appeal recently. That should in fact be, that reference isn't quite correct. It should be 13 rather than 1323. Apologies for that. Two appeals to the Court of Appeal, as I say. Woodcock was a police appeal from the decision of Mr. Justice Ritchie that the police owed and breached duty of care to protect the claimant from attack by her ex-partner G after the neighbour reported the ex-partner's presence in her vicinity by dialing 999. In CJ, Mr. Justice Martin Spencer dismissed claims by a number of children for the police failing to protect them from sexual abuse, which were inflicted by a male who'd previously come to police attention in relation to allegations of downloading child pornography. In Woodcock, the court focused on comments in previous, the claimant focused on comments in previous House of Lords and Supreme Court decisions that a duty of care might arise in exceptional circumstances. The Court of Appeal rejected that suggestion. To treat this case as falling into the exceptional category in which Ms. Woodcock relies would render the general rule inapplicable in a substantial number of cases and would be likely to lead to uncertainty and inconsistency. That's important because you can find a number of statements in the older cases to the effect that there could be exceptional cases where the usual rules don't apply. This decision, if it's correct, squashes that notion. The claimant's case had to be examined under the general rules. In relation to assumption of responsibility, they said that it will normally be necessary for the claimant in a case like this to show something by way of a special representation or promise by the police to take particular action. It will also generally be necessary to show that the representation or promise was relied on. Here, the police did nothing to create an assumption of responsibility, either to warn the claimant of G's presence or to prevent an attack by him. In relation to the interference principle which was relied on, they said there was no evidence either that the police were aware that the neighbour would take action or that the call handler in any way stopped the neighbour taking action. And then they rejected the application of the control exception as well. Notice, interestingly, the court upheld the factual findings of breach and causation that had been made by Mr. Justice Ritchie. This, therefore, is a good illustration of the fact that a case can still be won by the police on duty of care grounds, even when they're negligent and that fault has caused injury to the claimant. In the CJ case, they dealt with this briefly. They said it's clearly an omissions case. Had the police taken no action at all on the allegations of pornography, then the claimant wouldn't have been in any better position to avoid being abused by the perpetrator. There was no evidence in the case to support the arguments that the officer either made matters worse by not allowing more qualified or more competent colleagues to take over, or caused family members not to take steps. Those were just assertions, unsupported by any evidence. So that appeal was dismissed. So just to summarise then, when one's dealing with claims, no matter which side one's representing, here's a few tips as to how one might approach with considering a negligence claim. Firstly, is the case about allegations of causing harm, or is it about failing to protect or failing to prevent someone else causing harm? Look at the substance of the case. The Calmer case supports that. That approach has now been confirmed in Tindall. What's the case really all about? What are the police actions and omissions about what the case is all about? Consider the formulation in Paul. This distinction between causing harm and failing to confer a benefit. Remember that formulation, because acts and omissions, that terminology can mislead. Once you've done that, focus on this question: were the police actions authorised by legislation? This has been a rather overlooked element. Hasn't yet been considered extensively in the case law. But the logic of what was said in Robinson is if the police have the power or duty or possibly the power to do something, then they can't be liable in negligence for doing that thing. An example might be where the police have power under section 117 of PACE to use reasonable force, and no more than reasonable force is used. It's arguable, it seems to me, that it would be inconsistent with that power to find that there was a duty of care and the police breached it. That wasn't considered in the case of Robinson at all. Or it might be that it only applies, that the section only applies to force used against the person detained. So that's an open question. It seems to me to be worthy of further consideration. And then finally, if it really is an omission case, does any of the exceptions apply? So consider what Tindall says about the Tavares and Steele formulation. In relation to assumption of responsibility, what have the police done towards the claimant as distinct from the general public, which is said to create the assumption of responsibility, and how have they relied on those police words or actions? Secondly, control. Well, control of what is the first question. And then secondly, is it alleged that there was actual control over the person or process or scene or whatever it is, or merely are they merely complaining of an ineffective attempt to control it? And then the interference principle. What person or agency is said to have been interfered with? Did the police prevent that person or agency protecting the claimant, or did they just fail to cooperate or seek assistance from that person or agency? And were the police aware of the agency's involvement or potential involvement? So that's hopefully a useful gallop through where we are now with negligence claims. So what I'm now going to do is hand over to Richard to deal with tasers.
Good afternoon, everybody. Hopefully you can now see me. Has the camera swapped from all to me? If somebody could raise their hand if video is working as it should do. Yeah, I'll share this now. Share. beginning. Um, so I am talking today about use of force, and in particular, in the context of tasers. Like Paul, I'm going to have to do something of a gallop through this subject. There are a number of interesting and important recent cases. There are 5 of them listed there. The two leading Court of Appeal decisions of McCarthy and Afriyie are the ones that I'll be focusing on. But there are also 2 High Court decisions there in Gilchrist and Amadou Abdullah. And then finally, I've just popped in at the end Paul's case in Plumley, which is unreported but did get picked up in the reputable Daily Mail. So just a little bit of general info here on the rise of the taser. The name Taser is actually just the company that makes the stun gun. It's a prohibited weapon under the Firearms Act. The key bit here is that use is broader than merely firing it and shocking the subject. It includes drawing, it includes arcing, which is just the sparking of the device. It includes aiming it at the subject, aiming it with the laser sight red dot onto the subject, firing it so that the probes are discharged, but there is no actual stun provided. It includes then obviously firing it with the probes being discharged and then the application of the stun. It includes unintentional discharge. Now, the relevance for litigators, these all potentially amount to uses of force, which the officer then must account for. And this may feature in cases which at the outset don't appear to be primarily about tasers. There may have been then, taser withdrawn and pointed and then put back in the holster and then, other types of force used. And at first blush, it may seem to be about the subsequent use of force, but it's worth bearing in mind that actually that use of the taser, the withdrawing from the holster and the pointing, that amounts to a use of force as well that needs to be accounted for. I'll move on to the next slide here. So this is the APPAP. Now, the College of Policing produce this guidance, this authorised professional practice. They've done one, they've done a series actually, for taser use. We have here the Armed Policing Conducted Energy Devices guidance. There are a number of points here. I don't have time to go through all of them, but the main one there is highlighted in bold. So taser should only be used as a proportionate response to an identified threat. It should not be used to simply gain compliance with instructions or procedures where compliance is not linked to such a threat, or where a threat has been reduced to such an extent that taser use would no longer be proportionate. So it has to be proportionate. It has to be in response to an identified threat. It shouldn't be used simply as a tool of compliance, or at least where the compliance is not linked to the threat. So where there is a link between the need to enforce compliance and the threat that this suspect poses to the officer, the guidance would, on my interpretation of this, would allow for taser use there. But as simply as a tool of compliance with the suspect doesn't otherwise pose any kind of threat, and circumstantially there's no threat, then a taser shouldn't be used simply because it's an easier way of affecting restraint. I'll then move on. Just a final bit there at the bottom is that officers should give a clear warning. We have here some explications of the relevant legal tests. Now, I'll start with the end, which is to do with negligence, tort of negligence. As we see their reference to Robinson, Paul discussed Robinson, other Supreme Court cases on this point, that police officers owe a duty of care, like ordinary citizens, to avoid causing reasonably foreseeable personal injuries. As Paul highlighted at the end, there are potential complicated points to be made about negligence in the context of use of force. But the starting point is, per Robinson and Michael, that police officers need to avoid causing reasonably foreseeable personal injuries. In terms of trespass against the person, which is the other relevant sort, and is normally how these cases are pleaded and understood, we see Lady Justice Hallett's kind of explanation there in McCarthy. I'll come on to consider McCarthy in some detail in a moment, but Lady Justice Haller explains that there's no need to demonstrate an intention to injure, so there's no need for a kind of mens rea. But that once a prima facie battery is established, when there's that the touching, the burden of proof in a civil action shifts to the defendant to justify the battery. In this case, by the commissioner establishing that his officer acted in lawful self-defence, the prevention of crime, or to effect an arrest. And in the same case, Lord Justice Burnett gave some helpful guidance as to the difference between civil and criminal context. So he explains that in the criminal context, the prosecution actually has to disprove self-defence. So, for example, if the defendant's been been charged with GBH, but he says that he did it in self-defence, the prosecution then needs to disprove that. But conversely, in a civil context, the burden, if they allege self-defence, or they raise that as a defence, the burden rests on the defendant to prove it. Similarly, in terms of whether there's a need to demonstrate reasonableness of belief. So in criminal law, a defendant can successfully rely on the defence of self-defence if they genuinely believed it was necessary to use the force, even where that belief was unreasonable. So even if a neutral bystander on the fringes of the interaction were to look at it and to think there was no reasonable need there to use any force, certainly not a degree, that would still allow for a successful defence of criminal law. But conversely, with civil, there are really three things that the defendant has to show. So first, that he or she honestly believed that it was necessary to use the force. That belief needs to be reasonable. So irrespective of even the nature and degree, the mere act of using any force at all, that needs to be reasonable. And then third, the nature and degree of the force. So not just whether it's okay to use force from the outset, but then actually what was done and to what extent, that needs to be objectively reasonable as well. And we'll come on to the fact that the Court of Appeal has slightly further explained or arguably embellished the kind of meaning of reasonableness there in really emphasising the need to demonstrate proportionality. So we'll move on to just the relevant statutory provisions. I won't read these aloud, but it's Section 3 CLA and Section 117 PACE. Effectively, they're just saying, reasonable force in exercising police powers. But it's those two words, reasonable force, which are up for grabs. Moving on to McCarthy, I've kind of tried to summarise the facts there as neatly as possible, but I'll distill them further. The police officers turned up to a big fight at a Premier Inn where the claimant was at this point inside the hotel with his mate Clinton beating up someone helplessly on the floor. One of the officers, Woodman, manages to make it inside the hotel. PC Burns, though, being blocked by another of the claimant's group. PC Burns remains outside. Upon seeing PC Woodman come in, the claimant and his friend Clinton try to flee. The claimant makes it out past PC Woodman into the view of PC Burns. And what PC Burns then sees is the claimant, despite having made it past Woodman, he then turns around and forcibly pushes Woodman down to allow his friend Clinton to be able to also flee. What PC Burns then experiences is both the claimant and his friend running towards him with their arms out, running directly at him. So PC Burns, who already has had his taser drawn at that point, actually pointing at another of their group, turns and points it at the claimant and fires it and stuns him for using one burst for approximately 6 seconds. The claimant fell onto PC Burns. They tumble down some stairs. They're having a bit of a scuffle on the ground. PC Burns attempts a distraction kick, which doesn't quite work. The claimant gets to his feet, tries to run off. So PC Burns kind of applies the stun of the taser again because the probes will still be in. So he applies the stun again. This time, however, the stun's used for longer, so between 10 to 11 seconds, which caused the claimant to fall and suffer cardiac arrest. Now, the crucial issue here is what PC Burns's explanation for why he fired the second taser for more than 5 seconds was. And he said he only intended to fire it for 5 seconds, but he had been distracted while applying the stun. He'd been distracted by the claimant's friend Clinton, who was advancing towards him aggressively and abusively. And, he feared that he was going to be attacked. And so because of being distracted, he, one may think understandably, wasn't keeping a count on the number of seconds that he was using the taser for. Now, the first instance judge recorder Alan KC held the police liable. With complete respect to recorder Alan KC, it does seem quite a surprising decision. But he found that the failure of PC Burns to exercise essential and appropriate control of the taser, i.e. just firing it for longer than he intended to, was not justified by the actions of Clinton, who was the claimant's mate that was running at him. There are a number of grounds of appeal. I'm not going to be able to go through them today. The main one is just the defendant saying, well, this just sets the bar far too high for a police officer who's discharging his taser in genuine fear for his own safety and or for the safety of others. And the Court of Appeal agreed. So Lady Justice Hallett there in a characteristically impressive and fluid judgment. In the second of the quotations there, in paragraph 22, gives a very coherent kind of overall description of the situation, explaining the kind of sense of fear that PC Burns would have been in. And she goes on to identify in the sentence in bold there what the key issue was, which was that he did not intend to keep his finger on the trigger for longer, but was distracted by a possible attack. In those circumstances, to find that the use of force was unreasonable was, in my view, to set the bar the appellate must meet too high. These aren't, and this is just my view, not Lady Justice Alice, but these aren't, finely tuned SAS soldier instruments of war that are involved in these situations. These are, ordinary men and women who are police officers. Yes, they're specially trained, but they're still prone to experience shock and fear and apprehension in very difficult, fast-paced situations like this. One of the many relevant parts of Lady Justice Hallett's judgment was paragraph 17, where she reiterates the age-old warning to appellate courts of interfering with first instance judges' findings of fact. But she explains that actually in this case, very little evidence was disputed on appeal or at first instance. And indeed, most of the recorder's findings of fact came from the CCTV footage, which the Court of Appeal had available to them. And those findings, actually, the Court of Appeal wasn't being asked to overturn. It is the conclusions that the recorder drew from those findings of fact that are subject to challenge. So she said, to my mind, as an appellate court, we are in an unusually good position to determine whether those conclusions were justified. Now, this may be the start of a theme in these taser cases of kind of appellate appetite for getting into the weeds of factual findings, but we'll come on to that in Afriyie. I don't have time to deal with the principle of trespass ab initio and what Lord Justice Burnett had to say about it. All I will say is that if you are met with a situation where it's the length of use of the taser, which is the kind of disputed thing. So where it's accepted that it was lawful to use the taser at the outset, but it was used for too long. And so there becomes a question about, well, the lawful and the unlawful bit of it. Just remember to come back to this judgment of Lord Justice Burnett. And it was only obiter, but it was endorsed by Lord Justice Leveson at the end in his concurring judgment. And it is also relevant for causation of future cases. If you can prove that sufferance of injury occurred during the quote-unquote lawful part of the application, then subject to obviously that being a very difficult evidential thing to prove, that could be a way out on, at least in part, causation. But I'll have to park that for another day. Gilchrist, this is a High Court case. This, I think, sits on the other end of the spectrum where, and again, with complete respect to the police force in that case, the first instance judge was correct to find that the police were liable. That case involved a middle-aged man who was autistic, bipolar, had significant learning disabilities, and essentially was having an episode of acute extreme dysregulation. He's very, very unwell. He smashed up his flat and in the process cut his hands badly, and then charged outside with blood all over his hands, no top on, no trousers, which I think predictably caused concern to members of public that saw him, so led to the police attending. They, somewhat fairly assessed him as acting aggressively and presenting a danger to himself and others. CS spray was attempted but was ineffectual, and then one officer tasered the claimant a number of times, and then a second officer tasered him subsequently a number of times as well, but cumulatively for over a minute, so 72 seconds of the application of stun. And Mrs. Justice O'Farrell found the defendant liable in that case for a number of reasons. I mean, 5 principal reasons being that the claimant was vulnerable and had been identified as such by the claimant's brother, who, at the point of the application of the taser, had presented himself saying to the officers, no, he's just not well. Secondly, actually, when, by the time that the taser was used, he wasn't attacking the officers, proactively. He was lunging at them when they approached him, but it was more likely to be defensive. So his behavior wasn't indicating that attack was imminent. Third, and this is one of the key issues in these taser cases, it was no longer an emergency. It wasn't a fast, dynamic situation. In fact, the claimant was moving slowly. So there was time to step back, let him calm down, give him some space, and try to use persuasion. And where the police were met with a highly dysregulated, vulnerable person who already had calmed down, one may think that they should have been able to deduce from that if they gave him some space, actually he might calm down further and it might become easier. There's no reason to think that he would just stay exactly as agitated as he was. Anyway, fourth, CS spray had already been used ineffectually, but that's a contraindication for the further use of taser because it increases the risk of injury. So that's something to bear in mind, that if the taser officer or another officer had already or has already used CS or Parva spray, they will probably then have to go somewhat greater a distance to explaining why the subsequent use of taser was justified. Finally, the taser had already been proven to be ineffective. So, one wonders why the thought was, okay, well, it hasn't worked for the previous 30 seconds, but I'll do it for another, 40 odd. Moving on to Afriyie, this is one of the two leading Court of Appeal decisions. I will do my best to summarize here, which is that the claimant wasn't, presumably still is a very big bloke. He's very tall, and you can see this if you Google his name. There's a photo comes up of him with his lawyers outside court. He's a very, very big bloke, well built, tall. He's 31 years old, which as a 32-year-old man myself, I like to think puts him in the territory of in his physical prime. He got pulled over for speeding. Police tried to breathalyze him. He gives a number of samples, all of which were insufficient. So the police arrested him for failing to provide a sample, but he makes absolutely clear from the outset that he's not going to comply with that. He physically resists. He pulls his arms away from the officers trying to restrain him. They can't even get the handcuffs on him. From fairly early on, PC Pringle drew his laser, points at him with the red dot, and another of the officers makes absolutely clear that there was a taser pointed at him and, was saying, we don't want to do this. But the claimant was defiant. He turned to his friend and shouted, I'm not going to allow this. Pulls his arm away from the officers. Taser officer PC Pringle shouting, do not struggle, repeatedly, but the claimant chooses instead to remove his watch. He throws it to his friend. But his friend, who may have been a touch more sensible, said to him, don't get tasered. But the claimant is still being asked repeatedly to put his hands out. He's being shouted at, put your hands out, do as you're told. But a period of time later, so about 20 seconds later, he instead folds his arms and just ignores the police officers and continues to speak to his friend. So PC Pringle decided to taser him, causing him to fall backwards and strike his head, thereby causing injury. He brought a claim against the police for assault, battery, and misfeasance. And at first instance, Mrs. Justice Hill dismissed dismiss the claim in a judgment that, to my mind, was very considered and well reasoned. She found that the use of the taser was lawful and objectively reasonable, but Lord Justice William Davis disagreed, and the central kind of legal basis for disagreeing was that an assessment of the reasonableness, Lord Justice William Davis said, must involve a consideration of how proportionate that response was to the overall circumstances facing the defendant. So, as I said at the outset, when going through the applicable legal thresholds, there seems to have been something of an evolution here in terms of the things which a defendant must prove in justifying the use of force. There now is either a kind of sub-question within question 3 or a new fourth question, which is within demonstrating reasonableness. The defendant has to show, standing back, that it's proportionate overall. We also see here Lord Justice William Davis kind of piggybacking on what Lady Justice Hallett said in McCarthy about the appellate court being in an unusually good position here, so a different position to the ordinary case. The ordinary case being one where the appellate court should be reluctant to interfere with findings of fact, but Lord Justice William Davis said here, well, we've got the body worn, and albeit oral evidence was given by PC Pringle, nothing he said could contradict what was recorded on the body worn. So, in fact, we're well placed here to get to the weeds of the findings of fact. Now, I think the key point of the reasoning is at 42 there, which is saying that, well, Mrs. Justice Hill didn't consider the proportionality of using the taser. What she did was to consider two options, the two alternative options of parva spray and waiting, which she rejected, essentially being that the parva spray also involved a significant risk of injury, principally because the claimant, when sprayed, may then stumble out into the road and be hit by a car. And in terms of waiting, it would be futile because the claimant's already made absolutely clear that he will physically resist arrest. And Lord Justice William Davis explains that she rejected each of those options, but she did not stand back and ask whether the use of a weapon which carried the risk of serious injury to the appellant was a reasonable response to the situation. He goes on in paragraph 44 to say that a proper objective analysis of whether using a weapon classified as a firearm, which was reasonable, would have led the judge to conclude that it was not. And then Lady Cara Walton on the Hill, CJ, just concurs by saying that the use of a taser on the appellant, who at the time of discharge was standing still in a non-aggressive stance with his arms folded and talking to his friend, was not objectively reasonable in the circumstances. Now, I put a few of my thoughts there. I should say I'm aware that the commissioner there has applied for permission to appeal to the Supreme Court. I understand that application hasn't been determined yet. The commissioner has Waitman's instructed, and as I understand, for the appeal has instructed Lord Folkes KC of these chambers. Also, for one of the prospective interveners, we have highly esteemed Paul Stagg KC for the National Police Chiefs Council, the NPCC, and for the College of Policing, Andrew Warnock KC is instructed. So, I mean, I do feel a little bit insecure about giving my thoughts on this, given that we've got three of the most esteemed public authority servants of the country involved in it. And I should say that these thoughts are very much my own and I haven't spoken to them about it. So if they're wrong, it's only me to blame. My view on this, though, is that the Court of Appeal, with complete respect and deference, the Court of Appeal got it wrong because they criticised Mrs. Justice Hill for not stepping back and considering whether the use of taser was proportionate in circumstances. But what the Court of Appeal didn't do was to go on and say, well, what the officers should have done. And to my mind, Mrs. Justice Hill better embrace the reality here, which is that the officers, were required to actually step forward and positively arrest this claimant. They're not like ordinary citizens who can and are expected to walk away. Actually, these officers had to effect the lawful arrest. And where they are faced with a big physically resistant claimant like in this, or suspect like in this case, there is going to be no good option. There's going to be no option that doesn't have a significant risk of injury. That, unfortunately, is the inevitable result of where a physically very, capable suspect makes clear they're going to resist arrest. There is then no good option for enforcing that arrest. And to my mind, it is legitimate because what the Court of Appeal said here is, well, you know, the point you used the taser, he was compliant. Well, not compliant at least, but he was just stood there with his arms crossed. It's not like he was running at you trying to attack you. But that ignores the prospective threat of violence that the officers had to factor into their risk assessment, because they would have been thinking, yeah, he's not doing anything right now. But when we have to go over and try to arrest him, he's going to physically resist then. So what on earth do we do? And so that the kind of prospective assessment of what the suspect is going to do on the basis of their behaviour from the point that the police became involved to the point of deciding how to achieve restraint, I think is legitimate. And so, you know, if you use the analogy of, you know, if you've got the heavyweight champion of the world in boxing, Alexander Usyk, who gets out of the car and says, whatever you do, I'm not going to comply and I'm going to fight back. You know, I use this just as an analogy, but what are the police officers supposed to do there? It also, I wonder about the appetite here of the Court of Appeal for getting into the findings of fact. And, you know, to my mind, I'm not sure this case is quite on all fours with McCarthy, because there was more significant disputes of primary fact in Afriyie than McCarthy. But I'll have to leave it there now because of the time. Madhu Abdullah is a recent 2024, like Afriyie, but it's a High Court decision of Mr. Justice Ritchie. I've spelled out some of the facts there. One may think, reading the facts and then moving on to the findings, the findings were quite surprising. But I'll have to leave that for the readers to include on their own. And just finally, this is Plumley, which is Paul's case. Again, there are some of the facts there, but for timing reasons, I have to move on. Just very quickly on themes. If one of these cases comes across your desk, ask yourself, was the taser used for a tool of compliance, or was it in active self-defense? If it was the former, you're more likely to have problems with liability. If it's the latter, more likely to be deemed lawful. Was it a fast and dynamic situation like in McCarthy, or actually at that point that the taser was used, had the suspect or the claimant kind of, you know, stopped moving such that the police had time to step back? Remember that the length of taser deployment has to be justified. If it's more than the initial burst of 5 seconds, then that's going to need extra justification. Highly dubious as to the principle of trespass ab initio. Remember to look at whether negligence is pleaded. That kind of ties in with the trespass ab initio point. Have the officers' accounts evolved over time? So think about what they did and said in the body worn, what their use of force form says, what the MG11 says, what their witness statement, civil proceedings says, what they said in oral evidence at trial, and consider whether or not there's a thread of consistency across those accounts. Does seem to be an appellate court appetite for overturning findings of fact, or at least interfering with conclusions drawn from findings of fact. How long has the police officer had the taser, and how many times have they deployed it? So if they've been taser trained and had a taser for 9 years but only used it twice, that might be a good factor as to, you know, suggesting that they're not a kind of, you know, trigger crazy bully. And remember that use is broader than simply firing and shocking with the taser. It includes other things as well, like even withdrawing and pointing. That's everything from me. I then will hand over to Paul.
Sure. So, yeah. Richard, thank you very much indeed for that very lucid analysis. I think that summary of points at the end is going to be very useful for anyone who has to consider one of these cases. We've had some questions which I think are probably all more or less aimed at me, so I'll just deal with those quickly. First of all, the one that Vicky put in the chat. She says, on the basis of the case law cited, how likely is it that the police would be found liable for failing to apprehend a youth who was involved in previous altercations and group activities, including weapons, when that youth subsequently went on to stab another youth, killing him? The answer is, on those bare facts, unlikely. It seems to me there would have to be something unusual in the facts to take it outside. So, for example, if the youth was being targeted, if the victim was being targeted by the youth and perhaps associates, if there was a gang conflict, for example, and say the youth told the police, I'm scared, I'm getting out of London, and the police said, don't worry, we'll arrange protective custody for you, then that might, for example, be a case where you get an assumption of responsibility argument going. But on those mere facts, you're more likely to have joy with Article 2 than you are with a negligence claim. We had a few questions before, in advance of today's seminar. First of all, we were asked about how did the courts interpret the duty of care owed by the police in each case. In Tindall, how did the court justify its ruling? Hopefully I've explained that in my main talk. Could I cover whether these decisions are likely to have any further relevance to failure to remove cases? For the uninitiated, a failure to remove case is a case where the claimant complains that social services should have removed them from the family home when they were children. In relation to that, Tindall, I think, is of particular relevance, in particular the way it deals with the Tafaris and Steele exceptions, because the two leading cases on failure to remove, which are N and Paul, which was referred to in the talk, and the more recent case of HXA against Surrey and YXA against Wolverhampton, those cases centred around assumption of responsibility rather than the other exceptions. So Tindall is relevant in that it covers and gives some help with the scope of the other exceptions. And the final question is, if the police fail to establish liability in a road traffic accident matter, then what to do? I'm afraid I found that question a little bit ambiguous. If it's meant to say, well, the police should have prosecuted somebody for a road traffic accident, then I think it's right to say the police are unlikely to owe a duty of care to a victim of crime to prosecute somebody. In relation to the police failure in relation to gathering evidence, it's not the police's function to gather evidence to help somebody establish liability in a road traffic case. Their duty is to investigate criminal offences. So again, I don't see how that could amount to an assumption of responsibility to somebody who wanted to bring a claim against the police. So I hope those are helpful answers to those questions. We're very gratified to see that we've had such a good attendance for this webinar, over 100 people, I think. Thank you all very much indeed for attending, and from Richard and myself, I hope you enjoy the rest of your day. Thank you very much.